Hello, my name is Cesar Pereira. I'm this year the global president of the Chartered Institute of Arbitrators, and I have been the chair of the C.Arb Brazil branch. It's really my pleasure and my honor to welcome all of you to this new edition of our already traditional webinar on some of the Vis Moot issues. We have been doing that every year for about 3 or 4 years, and we are very honored also to always to have here with us for the substantive discussions of the Vis Moot problem, Professor Ingeborg Schwenzer and Professor Edgardo Muñoz. And as we usually do, this year again, we will have the pleasure to host here a specialist on one of the substantive topics of this year's problem, which, as you know, has to do with CITES, a specific convention on the trade of protected species. And we have here with us Professor Simone Ferreira, who is, as I will introduce her later, a specialist on that. This program is organized by my colleague Cristina Mastrobono, the chair of the C.Arb Brazil branch, and by me, with the assistance and support and as our media partner of Arbitration Channel. And so this is always a great pleasure to have this opportunity to discuss the Vis Moot problems every year with our guests. Before we move into our discussions, I'd like to very briefly, because if not, I would take our 90 minutes just introducing them. Very briefly introducing our guests. Professor Ingeborg Schwenzer is, as you all know, the lady CISG, literally a rock star. And if you haven't seen that, you will shortly in Vienna. You will see how much of a rock star she is. She is the editor of the main CISG commentary that has been published in many editions in English, in German, in Spanish, edited by our other guest, Professor Edgardo Muñoz, and even in Portuguese. And she is together with Professor Edgardo Muñoz, the author of a book that will come out very soon called Global Commercial Contracts, right? And that is designed specifically for students, for practitioners that are interested in commercial contracts. And it does not focus only on the CISG, but it's a comprehensive work on basically everything that you need to know about international contracts. And so keep an eye peeled for that, because that's coming out very soon. We also have here, lastly, I'd like to mention also that Professor Ingeborg Schwenzer, as you all know, is Professor Emeritus of Private Law at the University of Basel. And Professor Edgardo Muñoz is a professor of private law at the Universidad Panamericana, Guadalajara in Mexico. And as I mentioned already, he is the editor of the Spanish edition of the CISG commentary and co-author with Professor Ingeborg Schwenzer of the Global Commercial Contracts that's coming out soon. Both of them are members of the CISG Advisory Council, and you have certainly seen a lot of what they have written, preparing your memoranda for this year. And I'd like also to introduce our third speaker, who is Professor Simone Ferreira. Simone, Professor Ferreira, is an attorney based in Brasilia. She has extensive experience in the regulatory framework related to agriculture, to biodiversity, to intellectual property in those areas, and to innovation in agricultural products. She has acted as counsel and consultant for the Brazilian government for many years, for agricultural business companies, and for international organizations such as the FAO. She is specifically specialized on the CITES, on the convention that you have all been learning about this year with the Vis Moot problem. And so we will pick from her brain today to understand more about what CITES is, how it works, and how you can maybe develop some arguments for the Vis Moot problem, considering the reality in the application, in the interpretation of that convention. So moving on with our discussion today, we will focus on the substantive issues. And basically, just to remind you, the two main questions that have been posed to you with regard to the substantive issues are first, whether claimant is entitled to damages due to a breach of contract by respondent, which is not excused by Article 79 CISG. And then the second question posed to you is, in case claimant should be entitled to damages, can these damages be calculated on the basis of Article 75 CISG in the way claimant did? That is, by taking the difference between the price paid by Herbal Cosmetics for the delivery of 3,300 orchids on May 2024, and the price respondent would have paid for the same amount under the agreement. So those are the two basic questions that you have. But of course, we will deal today with a lot more than that. And as you know, the Vis Moot is above all an educational exercise, and we intend this webinar not only to prompt some reflections that you can use as you prepare for the oral arguments in Hong Kong or Vienna, but also and mainly for you to learn about CITES, learn about the CISG, learn about the issues that matter not only for the Vis Moot problem, but for your professional and academic lives as well. So without taking any more time from our speakers, I would like to give the floor to Professor Schwenzer for her initial presentation. Please, Ingeborg, the floor is yours.
Thank you very much, Cesar, for this kind introduction. I'm very honored and happy to be here today, and I thank C.Arb and its global president, Cesar Pereira, for having invited me again to speak here in this webinar. I'll speak about exemption under the CISG. Let me briefly outline what I'm going to talk about, if it were to work. Yeah, after a very brief introduction, I'll talk about exemption under Article 79 CISG and exemption under Article 80. And probably I won't have the time to talk about mitigation of damages under Article 77 and compare it to Article 79 and 80. As a way of introduction, let's remember the starting point of the different legal systems. We have a real difference between the Anglo-American legal systems and the civil law legal systems with regard to exemption from liability. The Anglo-American legal systems, going back to English law, follow a scheme of strict liability. So no matter what has happened, that was the old English rule, no matter what happened, the contractor was strictly liable in damages. That is very different in civil law legal systems. All of you who are coming from civil law legal systems, including Brazil, know that in civil law legal systems, liability for damages is fault-based. That means only if the contractor has been negligent or in another way faulty, he or she is liable in damages. So that was a big task when the CISG was drafted, and the CISG found a compromise. The starting point is the one of common law, namely strict liability. But exemption is possible under the CISG in Article 79 and Article 80 to a much larger extent than it is possible under traditional common law systems. So, like in many areas of the CISG, we have a compromise regarding exemption. So we have Article 79, Article 80, plus we do have Article 77 that allows for a mitigation of damages if the creditor itself did not act properly with regard to the loss. So let's have a look at Article 79, the basic provision that you all know already. A party is not liable for failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. We won't turn to the other paragraphs of Article 79, at least not now. What is important is paragraph 5 of Article 79, namely the exemption only concerns the possibility of damages. The other party still has any other rights, especially the right to avoid the contract if the breach has been fundamental. So let's turn to the prerequisites of Article 79. The first point is there must be a breach of contract. Any breach of contract leads to damages. That's the principle under the CISG. And thus, for any breach of contract, there can be an exemption under Article 79. So before we turn to the question whether there is an exemption, we have to decide whether the non-delivery was a failure on the part of the seller, non-delivery, or a failure on the part of the buyer, failure to take delivery. Thus, we have to explore when does delivery occur, and especially who must procure the necessary licenses, and that in every case it's the export license and it is the import license, and thus if there were no licenses either for export or for import, who is liable for this, and thus who is in breach of the contract. So how do we decide when does delivery occur and who must procure the necessary licenses? Here come into play the Incoterms. The Incoterms 2020, that was the edition of 2020, the 10th edition of the Incoterms, by the way, they specify in their different terms whether the seller is liable for procuring the licenses or whether the buyer is liable for procuring the licenses. And this is done in rules A7 and B7 respectively. The A rules always state the duties of the seller, and the B rules, on the other hand, the duties of the buyer under a certain Incoterm. For example, under the D terms, those that are most honorable for the seller, we have DDP, delivery duty paid. The seller is responsible to provide for the import license. The buyer must only assist the seller in procuring this license. Whereas if you look at the F terms, especially FCA, for example, free carrier, the seller is only responsible for procuring the export license from the seller's country, whether the buyer has to procure the import license to import the goods into its own country. So before you discuss whether there has been an exemption, you must discuss who is responsible for procuring the necessary licenses, and thus who is in breach of the contract. If you come to the conclusion that under the contract, it has been the seller who must procure the import license, the question is whether it is exempted under Article 79, and we saw the text of Article 79. What is required is an impediment beyond the control of the obligor. Usually these are force majeure situations like natural phenomena and catastrophes, like earthquakes and the like. But also the question is, are state interventions, so-called fait du prince, can these amount to an impediment under Article 79? And probably you have already found out that there are diverging opinions on these questions. There are some cases that say clear state interventions are not different from any natural phenomena. They can be an impediment beyond the control of the obligor. There are others who come to the conclusion that state interventions can never fall under Article 79, that the obligor must carry the burden of the state intervention of its own state. So what we have to look primarily to are contract clauses. Did the parties foresee this situation? For example, have they provided for this situation in their contract clause? And there you come to the hierarchy between the contract and the CISG. And that is very important because under the CISG, Article 6 of the CISG, you already know this provision, there is the principle of freedom of contract. That means the parties can always derogate from any provision of the CISG, except one, but that's not relevant here. So they can also derogate from Article 79. And even if there is case law saying that state interventions are not an impediment in the sense of Article 79, still the parties might provide otherwise in their contract. So first of all, look into the contract, and only if the contract does not say anything about this question, then you go to the CISG. So the contract and the contract clauses are always superior to the CISG. The CISG is not mandatory in this sense. What is also covered by Article 79 is hardship. That means economic impediments, change of economic circumstances, And there we have the problem, what is the relevant threshold for hardship? And again, we should look into the contract and the relevant contract clauses. So the first prerequisite under Article 79 is that we have an impediment, here a state intervention. Second and third, this impediment must be unforeseeable, and third, unavoidable. Unforeseeability is required at the time of the conclusion of the contract. So we ask the question, what would reasonable persons at the time of the conclusion of the contract in the shoes of the obligor have foreseen as possible impediments? And if this impediment was foreseeable for a reasonable person at the time of the conclusion of the contract, then there is no exemption under Article 79. Likewise, there is no exemption if the impediment has been avoidable, either at the time when the contract was concluded or just before it came into play. The obligor is also obliged under Article 79 to overcome the impediment or its consequences. So either it must avoid the impediment at the outset, if that is possible, so you have to discuss that, or once the impediment has occurred, overcome the impediment or its consequences. The standards regarding foreseeability and avoidability is very strict. Even increased costs or even resulting loss can be expected without exempt the obligor from its obligation to pay damages. So even if it's a bad bargain in the end for the obligor, still it must pay damages. Both criteria, foreseeability and avoidability, are heavily fact-driven, so you have ample room to work with the facts of the case to discuss Article 7 in favor of the claimant or in favor of the respondent. Very briefly, the other paragraphs of Article 79, 79.2 does not come into play. It's liability for third persons. 79.3, temporary impediments. 79.4, duty to inform the promisee once an impediment has arisen. And 79.5, we already discussed the consequences of exemption only relate to the duty to pay damages, but not to other remedies. Burden of proof is regulated in Article 79. The obligor who wants to be exempted from its obligation to pay damages must prove all the necessary facts, an impediment, unforeseeability, and unavoidability. I think Cesar, do I have the time to briefly mention Article 80, or should we?
Yeah, no, you have 5 minutes. Go ahead, no problem.
Okay, so the other possibility for an exemption is Article 80. A party may not rely on a failure of the other party to perform to the extent that such failure was caused by the first party's act or omission. So if you look at Article 79 and Article 80 of the CISG, we see different consequences. Under Article 79, the exemption relates to the duty to pay damages and only to the duty to pay damages, but not to the other remedies, as we have seen from Article 79, para 5. Under Article 80, however, Article 80 is much broader, all remedies are excluded, not just the remedy of damages, but also the remedy of avoidance, which is very important. Thus, for example, the buyer has to pay, although it does not receive anything. So all remedies are excluded under Article 80. Article 80 relates to an act or omission of the promisee if the promisee has caused the breach of contract, then the promisee does not have any remedy, any right with regard to the breach of contract. The problem is what, and that is very often the case, it's not just one party, but both parties have contributed to the breach of the contract. The first question is Article 80 applicable to these cases where both parties have contributed to the breach? If we look at the wording of Article 80, it's clear. The second half of the sentence states, to the extent that such failure was caused by the first party's omission. This clearly shows that also in the case where both parties have contributed to the breach of contract, Article 80 is applicable. The exemption then only relates to that part that the promisee itself has caused. We can then, the question is, what consequences apply in case of causation by both parties? You can apportion monetary claims and other claims. You can also adjust by the promisee making a payment in the amount that corresponds to the part that the claimant has caused the breach of contract. Yeah, and I want to stop here, and because I think the time that we agreed upon is up, and I thank you very much for your attention.
Thank you, Ingeborg. Well, I have a few questions for you here, but I think I will keep them until Simone and Edgardo speak. But I definitely want to go back to some of the things that you mentioned. Well, I am now we will hear from Simone Ferreira, and it will be a big change from everything that we have been discussing so far, because as I mentioned, she is a specialist on CITES, on the trade of agricultural products, of protected species in environmental law. And so, Simone, please, you have the floor, and we are eager to learn from you now about these very interesting issues.
And thank you for your kind introduction. And I will do my best following Professor Ingeborg. I think it's not easy, but I will try. And just a minute. So, and good morning or good evening, depending on where you join us from. And today I will share some of my experience working with CITES. As you know, CITES is the Conventional International Trade in Endangered Species of Wild Fauna and Flora. These international agreements plays a critical role in protecting endangered species by regulating how wildlife and plant species are traded across borders. CITES was established in 1973 and entered into force in 1975 and remains one of the most important global conservation instruments. And why CITES exists? And the main reason CITES exists is because unregulated international trade can drive species toward extinction. Right demand for wildlife products such as ivory, exotic pets, timber, and traditional medicines has historically caused serious declines in many species. CITES aims to balance conservation with sustainable use by regulating that trade is legal, controlled, and traceable. What is regulated? CITES regulates international trade in both living and dead specimens of animals and plants. This includes live animals and plants, carcasses, skins, bones, and parts, such as ivory, horn, shells, and scales. It also covers derivatives like medicines, leather goods, timber, and food products. The three appendices. CITES classifies the species into three appendices based on the level of protection they need. Each appendix have different rules for trade, ranging from strict prohibition to regulate trade and certification requirements. Appendix 1 includes species that are threatened with extinction. Commercial international trade in these species is generally prohibited. Trade is only allowed in exceptional circumstances, such as for scientific research. Appendix 2 includes species that are not currently threatened with extinction, but could become so if trade is not controlled. Trade in these species is allowed, but regulated from a permit system. Appendix 3 includes species that are protected in at least one country, which has asked other parties for assistance in controlling trade. Trade requires certificates, and when exported from the listening country, an export permit is required. How CITES works? CITES operates through a permit and certification system that ensures trade is legal, sustainable, and traceable. The process involves national authorities, scientific assessment, and border inspections. And step 1 is application. The process begins when a trader applies to the national managing authority for the requirement permit or certificate. These applications include information about the species, origin, and purpose of trade. Step 2, review. The managing authority consults the scientific authority to ensure that the trade will not be detrimental to the survival of the species and that the specimen was legally acquired. Step 3, issuance. If the application meets all requirements, the permit or certificate is issued. It includes specific conditions and a limited validity period. In Brazil, this period is 108 days, so it's a long period, it's not a short period. In step 4, transport and inspection. The specimen must be transported with the proper documentation. Custom officers inspect and validate the permits at border crossings to ensure compliance. Permit requirements. Permit requirements vary depending on the appendix. Appendix 1 with species require both export and import permits and must not be traded for commercial purposes. Appendix 2 species require an export permit only, and Appendix 3 species require a certificate of origin or an export permit for the listing country. General rules and principles. CITES is based on precaution, sustainability, and international cooperation. Trade is only allowed when it can be demonstrated that will not harm wide populations and that specimens were legally obtained. Exemptions and a special case. CITES includes certain exemptions, such as personal effects under strict limits, pre-conventional specimens acquired before listing, and specimens bred in captivity or artificially propagated. There are also simplified procedures for scientific exchange and special certificates for traveling exhibition. CITES governance structure. The CITES has a structured governance system that includes the Conference of the Parties, the Standing Committee, and the Secretary, supported by technical committees. Conference of the Parties. The Conference of the Parties is the supreme decision-making body of CITES. It meets every 2 to 3 years and includes all parties. The COP amends the appendices, adopts resolutions, reviews implementation, and sets the budget. Since 1976, there have been 19 conferences. Standing Committee. The Standing Committee acts as the executive body between COP meetings. It has representatives for each region and oversees the secretary budget, coordinates regional activities, and monitors compliance. Decisions are usually made by consensus. Site Secretary. The Site Secretary is administered by UNEP and is based in Geneva. It facilitates communication between parties, provides technical support and training, monitors compliance, maintains trade database, organizes meetings, and conducts public awareness activities. The Animals and Plants Committees provide scientific and technical expertise. They review all species, propose, and conduct periodic reviews. And there are other working groups address nomenclature, finance, compliance, and scientific diverse issues. And the decision-making process. The decision-making process begins with a party submitting a proposal to list or amend a species. The animals or plant committees review it, followed by the debate at the COP, and amendments require a 2/3 majority vote and enter in force 90 days after adoptions. Normally, the entire process is beginning in one copy, and then in another copy, it's final, the final votation, the final debate. So between 2 and 3 years at least to change anything in an amendment. So it's a long process. CITES and domestic implementation. Although CITES is legally binding, it's not self-executing. Each part must implement it through national legislation. Domestic laws ensure that trade is legal, sustainable, and traceable. Minimum legal requirements under CITES. National legislation must designate management and scientific authorities, prohibit illegal trade, provide penalties, and allow confiscation of illegally traded specimens. CITES legislation categories. Countries are assessed based on how well their legislation meets CITES requirements. Category 1 means legislation generally meets requirements, while categories 2 and 3 indicate partial or insufficient implementation. National implementation. At the national level, the management authority issues permits. The scientific authority evaluates impacts on species, and enforcement authorities, such as customs and police, ensure compliance. Enforcement and penalties. Enforcement is the responsibility of each party. Penalties can include confiscation, heavy fines, imprisonment, and even international trade sanctions. International cooperation is essential to combat wildlife trafficking. And case study, Vanilla planifolia. This case study focuses on Vanilla planifolia, a vanilla orchid species native to parts of the Americas. It's one of the main sources of natural vanilla due to its right vanilla content. Its trade raises important questions about sustainability and regulation. And possibilities to be considered. Key considerations include developing hybrids or alternative species, permit validity periods, reservation by parties, treatment of artificially propagated plants under Article 7.4, and how amendments enter into force under national law, especially for ongoing contracts and materials in transit. Resources and information. For further information, the official CITES website provides comprehensive resources. Species Plus helps identify species listings. National managing authorities can assist with permits, and the CITES Virtual College offers free online training courses. And thank you for your attention. And that's it.
Thank you, Simone. Yeah, well, I was really curious about some of the things that you said, and we'll go back to issues like the artificially propagated species, and in this historical issue that these changes are not implemented immediately, right? But of course, in the Vis Moot Problem, there are some adjustments of that reality. But I would really like to go back to you about that in a moment. And so to finish this first part of our discussion, I would like to ask Professor Edgardo Muñoz to talk with us a little about the damages issues and things that are related to the second part of the substantive discussion. So please, Edgardo, the floor is yours.
Thank you very much, Cesar. It's a great honor and pleasure to be here with you. I learned so much from Simone Ferreira, a very interesting topic and so important for today's work. And also, obviously, being here with Professor Ingeborg Schwenzer, who is a mentor and colleague, much admired, and with Cesar Pereira, a dear friend, esteemed friend, and currently the global president of C.Arb. So I will be speaking about two provisions which are relevant to issue, I believe, is issue 4 of the Moot Problem, which are Articles 72 and Article 75 of the CISG. The first of them is anticipatory avoidance, and the second one deals with damages, and in particular, how to calculate damages in a concrete manner. So it works. There are 3 questions that could lead our analysis here. The first of them is the main question in 72. And this question is whether there was a clear fundamental breach that would happen in future. And as you know, this is relevant because according to the facts of the case, the window to take delivery was still open, right? When the avoidance or arguably avoidance of the contract took place. The second question is whether the party who avoided the contract allow an opportunity to give assurances that it would perform, right? And the third question is whether the covered transaction, which is the basis for calculating damages, was a true substitute, and whether this was made reasonably and in time. So as to the first question, there is a policy underlying Article 72 CISG, and this policy is to protect the party who fears the future breach of being just trapped in a contract, which consequences or bad consequences are clearly foreseeable before compliance or performance become due. But on the other hand, the CISG also has a policy of preserving the contract. So this article, while allowing exceptionally to avoid the contract prior to the date of performance, also imposes some strict requirements for that. And we were going to check those requirements now. The requirement is that the avoidance, and otherwise this article doesn't work, you should go to a different article of the CISG, that the avoidance takes place before the date of performance. The second requirement related to paragraph 1 is that there is clarity that the other party will commit a breach, but most important, that that breach will qualify as a fundamental breach under Article 25. And as you know, Article 25 requires that the breach deprives the party from what it is expecting to get under the contract. And although this provision doesn't tell us much, there is a lot of case law and scholarly writings about what may constitute a fundamental breach. Arguably, the failure to take delivery of the goods qualifies like that. Then the requirements of giving notice that the contract will be avoided unless the other party provides assurances that it will perform. And so the notice must be reasonable. It must convey the intention to avoid the contract, and also give an opportunity, give some time to provide adequate assurance. 72 has an exception to this second requirement and is in paragraph 3 of the same provision. So non-notice may be required when the other party has said that it will not perform. So that related to the first paragraph, it becomes clear that a fundamental breach will happen, right? And now, how this plays into the fact patterns you have. I'm not going to refer to specific facts. You know them better than I. But we can see here the arsenal that each of the parties has or needs to bring up to the hearing now, or should have brought into the, probably should have brought into the written memoranda. Claimant will support, obviously, the clarity of a fundamental breach and will rely on respondents' communications, right? Suggesting inability to obtain the authorization and therefore to take delivery. It will also may rely on the regulatory shift. Simone already spoke about how a species, and you know, changes from one appendix to the other, and whether this current change basically showed that it was impossible for respondent to comply. And also it may rely on commercial constraints that the respondent has conveyed, has communicated. On the other hand, respondent is going to attack the clarity. It's going to say that, well, there was still a big window open for performance, and that actually his statements doesn't show clarity. It only shows concerns, right? But it never, he may say, they cannot be construed as my denial to perform or something similar. And as Ingeborg said, in the case file, there are sufficient facts so that you can play with both positions and try to convince the tribunal that the party you are representing on that specific moment has a reason on this provision. Regarding the notice and adequate assurance and the exception to it, as I mentioned, there must be reasonable notice that the party intends to avoid a contract and provide some opportunity to provide assurance that it will comply with the contract. Otherwise, that party obliged to provide to give notice may rely on the fact, again, that the notice was not either practical under the circumstances because fast actions needed to be taken to avoid further damages. And here we are in the realm of Article 75 CISG on mitigation of damages. Or it may rely again on a declaration of respondent that it would not in any case perform. So in your argument, obviously you can frame it alternatively. You may say we provide, there is some evidence in the record where we actually, with some communications, provide an opportunity for respondent to react, to tell us. But in any case, alternatively, there was no need. Respondent is going to try to attack this, saying that any of his declarations, claimant's declarations, or even their answers could be construed as a notice or a refusal. Now we turn to Article 75, the damages mechanism. And, you know, as I mentioned, this is a provision that works together with Article 74, which is the general provision that allows a party to get full compensation. You can obtain performance damages, loss of profits, consequential damages, incidental damages, all those doctrinally categorized type of damages that in a way put the party in the position it should be had the breach not occur. And this provision, different to 76, is based on a concrete cover purchase. And as Cesar mentioned, the idea is that you calculate your damages by taking the difference between the contract price, between claimant and respondent, and the price to which claimant later on sold the goods, the goods to Herba Cosmetics. And to analyze this question, there are some steps you may take or test you may ask in both the position of respondent or in the position of claimant. First, the article requires an avoidance of the contract, right? Was avoidance actually given, communicated? That's a question you may ask, you may argue against or for. Second question is, did the avoidance occur, did the cover purchase, in this case actually is a sale, the cover sale occur after the avoidance of the contract? If we take literally Article 75, you may argue, well, as a cover purchase took place, cover sale took place before the avoidance of the contract, you cannot even use Article 75, sorry. So obviously time matters. Timing determines whether 75 applies, but I don't believe, probably, I don't know, that giving a declaration for avoidance in all cases may, after the cover sale took place, may prevent a party from using 75. That should be argued. Actually. And then the second test is whether claimant, in this case the seller, really performed a substitute transaction, or whether our respondent may argue that was an acceleration or modification of a pre-existing relationship. And there are ample facts again there to argue for both positions, a genuine cover sale or something different, something which was more of the same with a pre-existing legal business partner. And then the reasonable time on which the sale was made, right? Claimant may argue that a rapid, swift response to imminent non-performance was required, and therefore he was actually complying with his duty to mitigate damages under 77. Respondent may try to argue on the basis of what we know in the record that it was premature, and that it should have probably wait and find other potential buyers to which it could sell to a higher price. And then the reasonable manner, which is actually connected to timing. And basically is that whether claimant was in a way forced to accept a price that was not reasonable under terms that were not reasonable as gain, etc., etc. So this is my final slide, and these are the anticipated questions that some tribunals may have, and the abstract answers that we can provide from now. I want to say at this point that nothing that I have mentioned in this presentation reflects my personal understanding or opinion of the case in a specific hearing. But I think we can, in the abstract, say that these are, the big questions with regard to 75 was there a right to avoid the contract, which is linked to Article 74, 72 in this case, whether there was a notice given to respondent to provide adequate assurance, whether there was a notice of avoidance. What happens if you get to prove that Article 70, that the cover sale was not reasonable? Can you just dismiss all the claim for damages, or can you simply reduce the amount of damages, considering other factors like the market price at an adequate point in time, etc., etc. And that would be it for me. Thank you very much.
Thank you, Edgardo. And we have already a few questions here from the Q&A. And I was curious to ask you, just to start with you, Edgardo, something about, I think your first question in that final slide, when you talk about really whether it's absolute, this requirement that the cover sale takes place after avoidance. And my question about that is there any substantive reason why it should be after avoidance? Can we understand that requirement has to do maybe with the ability of the other party to supervise in any way that cover sale, to know what's going on and maybe avoid these unreasonable terms or something like that? So would you see something like not only a formal reason, just because it's written there in Article 72, but some substantive reason why it would make a difference?
Well, one of the reasons is certainty. The breaching party has a right to know where the contract stands, right? And to provide, in some cases, adequate assurance. And so if the cover sale or cover purchase happens even before the respondent, or in this case, the breaching party, knows that the other party considers this a fundamental breach or that the relationship should be ended, I think it doesn't protect the principle of preservation of contracts. And in any way, as you said, it's important that the other party knows for certain whether it can, access other remedies like cure, something that is in his own control and hands. I don't know what Ingeborg may think about this, but I think there are many underlying reasons for the fact that the avoidance of the contract should take place before the substitute transaction.
Maybe
Ingeborg, please.
Also to avoid speculation. Yeah, so to make it clear that now the contract has come to an end, and now we must calculate damages, and otherwise, if it's in limbo, then the obligee might speculate and make a cover transaction, and if it is advantageous, it keeps the profit, and if not, it asks for damages.
But in this in a situation in which the party that is the non-breaching party goes ahead and before avoiding the contract makes a cover sale or cover purchase, could we, like, thinking about that on the from the other side, could we think that that party simply undertook the risk of not being able to avoid the contract later, but if it indeed was able to avoid the contract because there was fundamental breach, then everything pretty much is cured, and the fact that sale took place before avoidance is unimportant because avoidance took place eventually. Is that a valid argument, you think?
I think there are two things: the right to avoid the contract and the duty to declare the contract avoided. I think that you must have a right to avoid the contract before entering into a substitute transaction. I think that should be the case. Otherwise, you are breaching yourself the contract if you are not delivering the goods, or if you are not paying the price and taking delivery. Whether you will be exempted from declaring the contract avoided, that's the declaration part, before making the covered transaction. I think there are many elements, and there is case law, and there is scholarship writings that said there are some scenarios that declaration of avoidance could be even, couldn't even happen. I mean, or even if it is late. Yeah, and this is what we talk about, because the other party simply refused to perform in any case.
Yeah, and there might even be an obligation to make a cover transaction under Article 77 to mitigate damages. If time is of the essence and there is no time for declaring the contract avoided, the obligee must act promptly, and otherwise it might be accused under Article 77 for not having mitigated the loss and turned to a cover transaction earlier. So again, you can argue both sides.
Yeah, and I before we turn to the questions from the audience, just one more thing, Ingeborg. You mentioned Article 6 in the fact that parties can derogate from Article 79. I was curious about this. Well, in this specific case, there is a provision in the contract about force majeure. And would there be a presumption that if the parties set out a provision about force majeure, that they are derogating entirely Article 79, or would the presumption be that you have to read both of them in parallel and see what's left from Article 79 based on what they wrote?
That's a typical question regarding contract clauses. It's a question of interpretation of the contract clause. And again, one side might argue with that contract clause, the parties entirely derogated from Article 79, and the other party might argue, oh no, it has to be supplemented by Article 79, what the parties meant in their contract. So this is a question of Article 8, and again, students have ample leeway to discuss the interpretation of the relevant clause. But start with the contract clause and not with Article 79.
Okay, yeah, thank you. In something similar to you, Simone, as I told you, I was going to ask you about this issue of the artificially propagated goods or species. Well, first of all, it's clear from the problem, if you read there, procedure order number 2, question 3, that it's not entirely certain how much or how many of those specimens were caught in the wild or were cultivated, and so it's kind of a mix. From a CITES point of view, do you think there is some type of presumption of whether this uncertainty could lead to the conclusion that those goods were artificially propagated, or if they were wildly caught in terms of the application of Appendix 1 or Appendix 2?
Yes. It's a different treatment if it's propagated artificially, it's from the nature. And normally in the countries there are another legislation, that's a legislation for the agriculture. So you have to resist this propagation to prove that it's artificially. So if you follow all the rules of the country, the country has another rules for agriculture propagation of plants, and you have to prove that it's artificial, it's not come from the wild. The problems for CITES, it's about the overexploitation. So the overexploitation, it's about the things, the material, the specimens come from the wild, not from the production. It's a different situation. I don't know if it's clear.
I think it is. Well, at least what I understood from what you were saying was that the party alleging that there is artificial propagation would have the burden to prove that.
Yes,
is that yeah? Okay.
But it's easier to prove that because normally you have a registration of the Minister of Agriculture, so it's easy.
But if you have a certain quantity of goods, and you know that some of them may have been caught from the wild, some of them may have been artificially produced, cultivated, but you cannot be certain which is which. Do you see anything from the CITES perspective that would give us any guidance about whether that would be considered artificially propagated or not?
No, it's the principle of precaution. So if you can't prove all of them are white from the
okay.
white.
That precautionary principle.
Yes, yeah. Yes, that's it.
Interesting. Well, we do have quite a few questions here from the audience. I know, Simone, that you have already answered one regarding the import license process. Can you please just comment that so that we have that for the whole audience?
Yes. The question is regarding the import license process. Simone mentioned that it can take a considerable amount of time. Can you affirm that the issuance of the permits is generally a lengthy process? Like the countries that are signatory of CITES know that the obtaining a permit is not a fast process. Is there any estimate time frame for receiving the license after the application is submitted? So the answer is the issuance of license is carried out through a system made available by CITES. So it's the same system for every country. And in general, this is not a lengthy process. However, delays may occur if the scientific authority takes longer to provide an assessment of the status of the species. And the processes of classify a species for inclusion in a specific appendices or for its transfer between appendices is slow. I think there is a little misunderstanding here. It takes at least 2 years until the final decision is adopted by the COP. This is an extremely political process. So the import license process is not lengthy. The process that is lengthy is the process of classifying a species for inclusion or for transfer between appendices. It's a CITES process.
Yeah, interesting. And I thought it was interesting what you mentioned also about the fact that normally these changes take 90 days to be implemented, right? And so in our Vis Moot case here, there is this exception that it was immediately implemented. And so I think you can confirm that that's not usually what happens, right?
No, that's not usual. Yeah. And even when you have 90 days to enter in force, there is another step that enter in force inside the countries. Entering in force internationally, so the country is it's obligated to consider it, but it's not self-executing in the countries. Normally needs a decree, one internal regulation to enter in force.
Yeah. I would imagine that may come into play when you think about the foreseeability of the situation, right? For the purposes of Article 79. If normally you have a 90-day period at least, this immediate implementation could be a surprise in a way, but will be probably one of the factors. But Ingeborg, we have a few questions for you here. The first one here is, how does the Incoterms passage of risk influence in assessing exemption from liability under Article 79?
Well, the Incoterms relate, and the passing of risk relates to the question whether there is a breach or not. So whether delivery has occurred or not. So that is what I discussed in the beginning. Only if you can assess a breach on the part, in this case, of the buyer, then we have to discuss the exemption question. If there was no breach, so then there's no question of exemption.
Mm-hmm.
That's the
Edgardo, please.
Yeah, I'm wondering whether the question also refers to what you mentioned about import permits, and the allocation of risk. Indeed, the Incoterms, depending on the Incoterm you choose, in most cases, except for D, and actually only DDP. Only in DDP, the seller has to get the import permit. In all others, is the buyer who gets the import permits. Now, I think there is something special about the facts of this case and the CITES, is that one of the import permits, the most important, when they concluded the contract, was not imposed on the goods. And so I wonder how this plays with the foreseeability, because obviously the buyer may say, well, under the Incoterm we chose, you needed to take care of all import permits. But the other party may say, well, yes, those import permits that were into place, or that at least I could have foreseen at the time of the conclusion of the contract.
Yeah. And there is another question about Article 79, Ingeborg. It says, when looking at the avoidability aspect of Article 79, is the party not reasonably expected to avoid the impediment due to an increase in the cost and logistical constraints, or would hardship be the only possibility in that situation?
Well, I think those are two different questions. Hardship relates to a change in the economic circumstances, and in our case, the impediment is that the question of an import license not being available anymore. So we have to distinguish between the impediment due to state intervention and the question of change of economic circumstances. And that in a way is related to avoidability, because under avoidability we ask the question, is it reasonable to avoid the consequences of the impediment or not? And with regard to reasonableness, we will discuss the question of costs. What is the price for overcoming the consequences of the impediment?
Do you think there is any objective test for this reasonableness? How much is how much is an excessive? Or where do we draw the line to know whether the sacrifice that the party will have to make to avoid is excessive or not? Is there any criterion that we can adopt, or?
Well, you would discuss, would a reasonable person incur these costs or not? And the reasonable person always, in the end, is the judge or the arbitrator, because it is her opinion or his opinion that counts what is reasonable.
Okay. Now, Edgardo, okay, there are a few questions here about Article 75, and one here says, are damages calculated under Article 75 CISG necessarily considered loss of profit? And using this basis of calculation, is it possible to differentiate between loss of profit, consequential damages, and other forms?
Well, usually yes. I mean, especially in a covered sale. I mean, unless the original contract, unless under the original contract the seller was not making profits, which can happen. Sometimes sellers sell for opening markets. Sometimes, actually, they sell at a reduced price, which is sometimes illegal as well. Because that would be dumping, right? But in most situations, the original contract has a percentage of profits in the price. We don't know how much is that usually, right? It's not revealed. It's not common. But if the idea of Article 75 is to actually recover the whole price with damages because you sold at a reduced price, so you take that price, and then on the top of that, you take the other part of the price that you didn't get from, you get it as damages. In a way, you are putting the position you would have been had the contract been fulfilled. And so there may be a percentage of profit there, probably. And so I know why this question is asked, right? Because there is a limitation of liability clause also in the contract, but I cannot say more. I mean, I don't think you don't need to check whether this limitation of liability also applies or not, and whether there was a real transaction with profits. But yeah, that would be the answer.
In the fact that Article 75 makes it a lot easier to prove that difference, would that be a factor to consider, that the requirements of Article 75 have to be complied with strictly, including the fact that avoidance has to take place before the cover sale? Because my question is, if you have to prove damages, you have to go into this detailed analysis of costs and like open the books basically. And in a cover sale, the calculation of damages is a lot easier, right? Because of Article 75. And so isn't that a strong reason to say that yes, you can prove it more easily, but then you have to comply with absolutely all the requirements of Article 75 or not?
Well, the idea is that you have to comply with the requirements so that you are not speculating, as Ingeborg said, that you don't speculate. You only use Article 75 if you made a very bad cover transaction, right? And then you would put again in the position you were. I think that would be the answer. You can also go through Article 74 and avoid all those requirements. Yeah, when it's just about when you are dealing with what is called compensation law, performance loss, and profits is easier to prove under Article 74 as well as 75. Probably consequential, incidental, other types is more difficult. I don't know what's your opinion on this, Ingeborg.
I think you can clearly distinguish between the loss regarding the value of the goods. That is the first thing, that you did not receive a counter value for your price. Yeah. So that is the value of the goods or the purchase price. And distinct from, and this is the only question that is covered by Article 75 and 76. 76 concerning the abstract calculation of damages for the value of the goods. And this is distinct from loss of profit that I could have made if I had unsold the goods, for example. And consequential damages, for example, I am liable for a penalty or the like. I'm liable in damages to my sub-purchaser and things like that. So I think we can clearly distinguish between the different kinds of losses, and Article 75 is only concerned with the value of the goods in the market. And in 75, we have the concrete calculation regarding a cover transaction. And in 76, we have an abstract calculation with regard to the market value of the goods.
Okay, good. And Edgardo, there is a question here about hardship. Maybe you could address that. It says, with respect to hardship, how much of an increase of costs can be considered as hardship? Is there any guidance that you can give?
Well, it's the same answer that Ingeborg gave. It's depending on the judge. There are some courts that an increase of 100%, I mean, like total loss or paying double, didn't amount to hardship. They consider that. So there are some other cases though there. I don't remember, but there is a Belgium
70% in the Belgian case.
70% was already hardship. Yeah, it depends. It depends. I know in this case there are a lot of facts that can be useful because it's not only the price, it's also collateral things that would happen. That can be considered collateral, yes, but it's difficult to answer. Yeah.
And now, just a couple more questions here, Ingeborg. There is one about Article 79, and it says, "My question is regarding Article 79. Are the three requirements to be met jointly, and what is the criteria to consider that the parties derived from Article 79 CISG?"
Yeah, well, first, if there is no impediment, there is no question of Article 79. Yeah, there cannot be any exemption if there is no impediment. And then, yeah, they are cumulative. Yeah, the impediment must have been unforeseeable. If it was foreseeable, there is no exemption. And unavoidable. If it was avoidable or could have been overcome, then there's no exemption either. So they must be cumulative and not alternative. And well, we already discussed the derogation from Article 79. It's it's a question of interpretation of the relevant contract clause.
Okay, thank you. And Simone, you answered in writing some of the questions from the audience. So can you please just give them an overview of the comments that you made in writing?
Yes, and about the question about the artificial production propagation, and CITES' primary concern is the exploitation of nature, wild plants. In cases where a plant is produced in a greenhouse or under cultivation, a species listed in Appendix 1 must comply with the rules applicable to Appendix 2, because this is an exception. And a question about if it's possible to separate the artificially propagate from wild ones. And normally, agricultural production is registered with Minister of Agriculture, whereas extractive activities are regulated by the Minister of the Environment. If the plant has not result from genetic improvement, the plant breeding, it is not possible to distinguish between a cultivated plant and one extracted from the wild. They are similar. There's not a difference. But one of the requirements for the license, for the permit, is proof that the specimen was obtained legally. So you have to prove that that specimen is obtained legally. If it's come from the greenhouse or cultivation, you have a special of the proof with the Minister of Agriculture. You register the greenhouse and the production, so you have the proof. And if you have extractive activities, normally you have a license from the Minister of the Environment, and you have to make some reports. So I thought it's about the normal practice concerning the validity of the import permits. And normally it's between 9 and 108 days, depending on national legislation.
So just to see if I understood it correctly. So normally, if a party says that it has specimens that came from the wild, and others that came from a cultivated environment. However, they don't know for sure which is which. That party will probably be in breach of some type of obligation, right? Because they should know precisely which comes from which. Right?
You should know.
Yeah,
it's not possible. Okay. They don't know. This is not possible. You should know.
Thank you. And just to end, we only have 1 minute here before our time is up. Edgardo, there is one question for you here that's still open. And it says, I would love to hear more about how liability limitation clauses interact with the calculation of damages under Article 75 CISG. And so can they prevent its application? Do they oblige the party to open their books?
So the CISG governs to what extent there is a limitation of liability, because you use Article 8 to interpret what the parties wanted, what the parties wanted to limit as liability. So you need to use, again, as Ingeborg mentioned, Article 8 to see what they meant with that clause. Now, the validity of the limitation of liability clause is not dealt with by the CISG. This is dealt by with the other domestic law or uniform law apply to questions of validity. In this case, the UNIDROIT principles have specific provisions on the validity of limitation of liability clauses that you may look at. And that's it. You use Article 8 to see what the parties meant with that limitation of liability clause and whether it was valid. And then you work with the facts of the case to see if it applies or it doesn't apply.
All right. Well, thank you. And with that, we came to the end of our time here. It's been wonderful to speak with the three of you about these very interesting issues, and I thank you so much for your time and for sharing your knowledge here with us. I thank again all our audience, and as you know, this webinar it has been recorded and will be shared online, and we have traditionally had thousands of views on these webinars, and I'm sure this is not going to be different. And I hope this has been useful for all of you in your preparation for the oral arguments in Hong Kong or Vienna. And thank you so much. Thank you, Simone, Ingeborg, and Edgardo. And I see you next time. Thank you.
Thank you.
Bye-bye.
See you.
Bye-bye.
Bye.